Accused murderer Bryan Kohberger is headed back to court, but first, his defense team is demanding the prosecution turn over new evidence they say is vital to the case. Plus, Kohberger's defense team adds a new face with experience in capital cases. But does that mean he will face the death penalty? We take a deeper look at the latest developments in the University of Idaho quadruple murder case.
It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing Xana Kernodle, from which she died.
In November of last year, 4 University of Idaho students, Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin, were found stabbed to death in their off-campus home. Weeks later, investigators arrested Washington State University PhD student Bryan Kohberger. At the time, he was at his parents' home in the Pocono Mountains of Pennsylvania. After the start of the year, Kohberger was extradited from Monroe County, Pennsylvania to Latah County, Idaho. Since then, he's been held at the Latah County Jail, only about 1 mile from the grisly crime scene. Ahead of next month's preliminary hearing, Kohberger's defense team is demanding new evidence from his arrest be shared.
Anytime you have a homicide investigation, law enforcement is going to want to attempt to look for any type of evidence, whether it be forensic or otherwise. And that would include any place that the defendant lives or lived. And in this case, they had gotten into his home in Pennsylvania. It appears that there is evidence that they recovered. Some of it may even be blood evidence, and the defense has every right to review that evidence to see how significant it is to their defense and their strategy.
Law and crime legal analyst Julie Rendelman says it makes sense that Kohberger's defense team wants information from his arrest in Pennsylvania, even though it was thousands of miles from the crime scene in Idaho.
Certainly when you're a defense attorney going into any type of hearing, you're going to want to have all the evidence in front of you because you're going to want to be able to potentially cross-examine witnesses that testify. And that would certainly include any actions taken by law enforcement to create potential probable cause for his arrest, and to be able to establish or argue that some of the evidence they recovered is either not reliable or witnesses are not credible.
This comes as investigators publicly reveal items that were recovered at Kohberger's Pullman, Washington apartment and storage unit, including hair strands, an Amazon Fire Stick, and a computer tower. But it's additional evidence that Kohberger's team is now seeking. According to a motion filed on May 4th, Kohberger's defense wants 6 key pieces of information turned over to them. That includes all body and dash camera recordings from Kohberger's arrest, all lab testing from any items collected at his parents' home, in their trash cans, or in his Hyundai Elantra, additional lab testing from FBI forensic reports, all recordings and notes from the Moscow Police Department, and any audio or video recordings from Kohberger's arrest and jail time back in Pennsylvania. Kohberger's attorneys had previously filed 2 motions in February and March for the evidence to be handed over. But according to Rendelman, there could be a good explanation why it hasn't yet been provided to the defense.
It's certainly possible that the prosecution has some or all of the evidence and they haven't provided it. There can be many reasons why they haven't. One is because the evidence is voluminous and they're really just putting it together in an organized fashion. Another reason can be sometimes that there is a potential protective order, meaning there's something in the evidence that they think that certain parties shouldn't see yet because of some potential danger to a witness. And the third reason, which is possibly one of the most likely ones, is that some of the evidence they may just not have yet. Lab reports take a very long time. DNA takes quite a while. And so it might just be that they don't have it in their possession to provide it to the defense at this point.
We are going to ask the court to set preliminary hearing out into June. We would request the 3rd or 4th week of June and probably 4 or 5 days for preliminary hearing. Mr. Kohberger understands his right to a timely preliminary hearing, and he's willing to waive the timeliness to allow us time to obtain discovery in this case and be prepared.
With a June 26 preliminary hearing date, Rendelman says Koberger's defense could request it be pushed back if they don't receive the information in time.
Look, a preliminary hearing is kind of a determination as to whether or not there's enough evidence to go to trial. So if I'm the defense attorney, I'm going to want every single piece of evidence that is relevant to the case. And by the way, I'm going to want a piece of evidence that the prosecution doesn't necessarily think is relevant, but I may think it's relevant. And I'm also going to want any type of evidence that might be exculpatory, something that might lean away from my client being the person responsible for this case, for this crime.
The June preliminary hearing is slated to last multiple days, and while that's not a common occurrence, Rendelman says it makes sense in Koberger's case.
Anytime you have a case of this nature that's dealing not just with direct evidence, but actually circumstantial evidence, you're going to really want to connect the dots for the judge. You're going to want the judge to understand why each piece of evidence relates and is relevant to proving that this individual committed a crime. And that takes time. It's very different than a witness getting up there and saying, I saw this individual commit a murder. When you're connecting the dots, when you're taking cell site information, forensic information, possibly downloads from a computer, it takes time to put that case together. And that's why it may take several days before the judge.